wants to make sure it looks like the business is still operating. So that generally, those are the types of obligations that may be excused, because you've also got things such as the governor's order, which may have forced you to close. But usually payment of rent is still likely due. What I do tell my clients though is, if you do have any issues where paying rent for as a commercial tenant during this time, talk to your landlord. I'm sure many of you have heard Governor Inslee has, issued eviction moratoriums, and there are certain protections in place, but that all mostly is for residential tenants. It does not apply to commercial tenants, except for that it prohibits your landlord, as a commercial tenant, your landlord cannot increase, or they can't threaten to increase your rent during this moratorium, which expires actually on June 4th. And it's only if you as a tenant have been materially impacted by COVID. So you would have to show that, it's affected your business, you've lost staff, or you've lost customers. And so if pursuant to your lease agreement, there was, let's say, a rent increase that was supposed to go into place, then your landlords are barred from doing that during the moratorium, which ends June 4th. There are 2 cities, however, so if you've got office space in the city of Seattle or in the city of Spokane, they have a 60-day moratorium for commercial evictions. So commercial tenants are protected in those cities for non-payment of rent. But statewide, there really isn't that much. You're still required to pay rent. Your landlords just can't increase the rent right now. So is there any questions does anybody have any questions about their commercial lease, or issues related to that? No? Okay. And just checking in again, making sure that everything is, everybody can still hear me okay?
Yes, this is much better with the phone line.
Good, good. We should have done this from the beginning, but that's all right. At least we have it now. All right, so let's kind of go into the next slide, which now let me make sure my PDF is not frozen. There we go. So employee contracts. So I don't know how many of you, utilize employee contracts. A lot of small businesses may not utilize them. There's a fair amount that do. One thing at a minimum is I tell my small business clients, you want to make sure you have an employee manual. So if you don't have an employee contract that outlines all the items that I've stated here, you at least your employee manual can outline, the benefits and compensation, the paid time off, confidentiality agreements. You can have your office policies related to dress code, or other things that are important. And as a general office, you want every single employee to abide by, and it applies to every single employee. So a good way to do that would be develop an employee manual that you, of course, update as things like the paid, Family Leave Act went into effect this year. So you want to make sure you're updating those. But what you can do is you can have a manual, and then when you have an employee that you're offering a new position to, you can provide them with an offer letter that will have the job title, the description, their employment period. And what you could say is the employment manual is incorporated in that letter. And of course, give them a copy of the employment manual that they have to sign, along with their offer letter that they accept and that they also have to sign. So it's something that can take some time to develop, but once you have it developed, it's fairly easy to update. So what I would do is highly recommend that if you guys don't have one in place, that you get that in place. Or you can also have an employee contract that you have every single employee sign that maybe has some of these policies, your compensation or your benefits, not so much your compensation because that will differ, but your benefits, your vacation, your paid time off, if you offer retirement, all of those things can be attached as exhibits as well to the employment contract. So these are the things where in business, it can take a while to develop. It can be a pain when you're doing it in the beginning, but it's so important. And it's important to have these policies in writing, because if there's ever a question about it, or if you ever get sued by an employee, or if you ever get audited by, you know, a specific type of state agency, you have these things in place. So some of the things I did want to discuss, like I said, you know, my caveat, I'm not an employment law attorney, but there are employment issues which come up in the course of being a business law attorney. And so if things get too nuanced, then we go ahead and we will consult with employment attorneys. But there were a few that happened last year and that went into effect this year that I want to discuss. And most of these apply to every single business, regardless of your size. And so the first one is mandatory arbitration. So, you know, courts are trying to make things as efficient as possible. And there can be a lot of employee suits or litigation that is for not a super high dollar amount, but, you know, it can still clog up the court system. It can still take a year or two to litigate. So one of the changes that happened in 2019 was that now for every lawsuit where the damages sought are under 100,000, it is now diverted to what's called civil arbitration. So you're not going to get the full-on trial or, you know, the jury trial. It's going to be an arbitration, and the purpose of that is that it's meant to be a faster, cheaper, kind of more seamless process. The amount used to be 50,000, so they've essentially doubled it. So it used to be that if anything was over 50,000, you would go through the regular track in court, the civil, you know, civil cases, which can take up to a year before they get to trial. But now it's a much faster process, I would say, with the arbitration, and the amount is 100,000. The other big change was the wrongful death. The wrongful death laws, in the past, it limited damages for family members of people who were deceased, deceased individuals who were unmarried and had no children. Their family members didn't have as many rights as they do now. So as of July 2019, basically parents and siblings of somebody who is deceased, unmarried, with no children, their parents and siblings are able to recover for emotional distress and also loss of love and companionship if somebody were to die or have a personal injury as a result of one of your products, one of your services, or something on the job, essentially. So that law has now expanded it where you can have family members also seeking damages. Do any of you use non-compete agreements with your employees? Okay, great. At least one person does. So starting 2020, for non-competes, basically there's a few things that have taken place. And one of the most important is that you cannot, the law prohibits you from requiring non-compete agreements for employees who make less than $100,000 a year. So there's other things for employees who make less than $100,000. You can still use non-solicitation or non-disclosures, but non-competes are limited to employees who make $100,000 or more. There's also a new law that took effect this year where it prohibits any enforcement of non-competes that are longer than 18 months. So if you've got a non-compete that, you know, was 2 years or so, it's now going to be unenforceable for any period that's over 18 months. It's a high burden in that there is one exception. The employer has to prove by clear and convincing evidence that that longer time period is necessary to protect its business. But what I can tell you is that's really, really high burden. And then with relation to non-competes, one of the big changes was for your existing employees. So if you have an existing employee and you are requiring them to sign a non-compete, and it has to meet the other criteria, so they have to, make over 100,000, it has to be less than 18 months, then you have to provide that employee with some additional independent consideration. So it has to be either some kind of bonus or a promotion, pay raise for this new agreement. And that's for an existing employee. That's not for an employee that you're just hiring on. So, you can't, essentially what the law now says is you can't require an employee to sign a non-compete. Otherwise, they'll be terminated if they don't sign them. That's not sufficient enough. If you want them to sign something, you need to give them, you're now required to provide some sort of additional bonus. And then one of the last changes to the non-compete rule was that employers are now restricted. You can't tell your employees they can't have second jobs. So, and that there is some qualifications to that, of course. So basically any employee who earns less than 2 times the state minimum wage can have a second job. And then there's, certain qualifications that go into that. So if you use the non-compete and you think it may be an issue, obviously these laws are a lot stricter. So you want to make sure you're complying with them because you can get sued and there could be damages assessed. And there's a couple other things actually that are not up here on my slide about some of the changes that happened in 2019 and 2020. One of the ones that's not commonly known, and actually maybe to some of you, but it wasn't to me, was the public discrimination law. So what that does now is it directs liability of an employee's action. So if an employee unlawfully discriminated against somebody in a place that is open to public, or to the public, excuse me. So if your office is open to the public and you have an employee that unlawfully discriminated, which can be a whole host of, there's federal protections, and even you as the employer did not know about it, you as the employer now have direct liability for the unlawful discrimination. And so what's something you can do? The biggest thing I would say is you want to talk to your insurance broker. You want to make sure you're adequately insured for these types of things. You want to make sure you have adequate liability insurance, adequate business insurance, because this is, you may not know the actions of your employers, yet you still are liable or could be liable for it. And then the last one was the Equal Pay and Opportunity Act, which went into effect July 2019. So this applies to employers of all sizes. So employers cannot ask for the wage and salary history of a prospective employee. So if somebody you're interviewing, unless that prospective employee volunteers that information. So you cannot ask for that anymore. The one exception is you can request how much they used to make after you have offered them the job and you have provided them their compensation plan. So, I don't know why it would matter after the fact. You've already made your offer, but that's the only time that you can ask. Otherwise, you cannot ask. And then this is a little caveat in there for employers that have more than 15 employees. And I know at least one of you do. If you have more than 15 employees, in addition to not being able to ask for the salary history, you are also required to provide information about the wage and salary ranges for that position. So you're required to provide that information to the individual. And that also applies to internal promotions and transfers. So if you've got somebody, if you're an employer with more than 15 employees, then you're going to have to then you're going to have to provide that information about the salary range for their position. And I know somebody just commented, it's hard to keep managers from asking about salary history. So this is where training comes into place. You have to remove questions about salary history from your applications and your postings. You can't say that, that's information that's required. And you need to notify everybody who's interviewing the employees that this is now a question that's illegal and they cannot ask for that. Okay, so are most people that are on the presentation, do you guys have office space? I know there's a few of you that lease, but are you in a traditional office setting? Okay, so I've got one yes. Yep, okay. Got somebody put yes, we're both. Okay, so you may be aware, the governor has issued his reopening kind of COVID requirements for reopening. And I'd like to hear, especially if any of you have any issues with employees maybe refusing to come back to work because of COVID, or because maybe they're making more while they're on unemployment, or any sort of, if they have medical concerns, I'd like to hear about that. And then really, I don't know, I posted the link here. I'm sure most of you are aware. So the governor released his requirements for professional services. So this would be, your accountants, architects, attorneys, engineers. If you're in an office-based occupation where you're serving a client, now you have a lot of requirements that you're going to have to follow. And if you don't follow these, then you could potentially be looking at, sanctions or being shut down, which is directly in the requirements that were posted by the governor's office. I, for example, have a client who just had to spend several $1,000s on getting one of those glass protector, the sneeze guards, in their reception area. And, they're a small business, and that was a huge expense for them, especially given how things are pretty slow right now. So the one thing I would highly recommend, and I posted the link here if you haven't done it, is to read through the requirements for reopening, because a lot of it is, somebody had posed the question to me earlier about your liability as a business if somebody comes in and gets sick and tries to sue you. Well, we're sort of in uncharted territory here, right? This is something that nobody really has experienced before, and the rules that are being put in place for some businesses are burdensome. But the rules specifically state if you don't follow this, then you are at risk of being shut down. So one of the requirements now is, you need to educate your employees about how to prevent the spread of COVID. You need to try to maintain 6-foot distance between your employees and any clients or customers that work in or walk into your office space. If that's not possible, then there's other preventative things, using barriers or minimizing contact. You have to provide protective equipment to your employees. So masks, gloves, things that may be, necessary to protect the spread or protect them from getting sick. There's actually also something in here where it says that, an employer has to screen their employees. So at the beginning of every shift, and I haven't read through this whole thing in detail, so this is just from me glancing over it, is that you might have to check their temperature or, ask every day about their symptoms. And part of it is, I don't know how long all these requirements are going to be in place for, but they are in place in order to reopen for an office-based occupation. Now, of course, for other types of businesses, there's plenty of other documentation out there. It's on the governor's website. And that will sort of outline if you have a very specific type of industry. But the one thing that's clear is that you now, as an employer, have to put into place, you're going to have to type up and post at each of your locations. So if you've got more than one office, and I know somebody said they've got multiple, you are going to have to post a comprehensive COVID plan on how you're maintaining exposure, how you are going to mitigate or try to prevent the spread, and a recovery plan. And it says specific, this is the language that's in the governor's order, is that the plan must include policies regarding control measures. So how you're utilizing PPE, protective gear, how are you maintaining on-location physical distancing? I mean, is it even possible for your employees to socially distance if they're sitting in cubicles, or really, depending on your office size? You're going to have to provide COVID safety training and a copy of this. So this plan has to be available at your location, and it has to be available for inspection by any state and local authorities. So, failure to meet this stuff could result in fines. It could result in you getting shut down. So it does put a burden on employers with these additional things that you're going to have to do for safety reasons. But hopefully, if you have any employees that are, reluctant because they're worried or things like that, you have done your part by putting into place what's required of you with the state rules. Oh, great. Somebody said we take temperatures every day, kept private for all employees. So were there any questions about kind of, it's on the governor's website. I would definitely say that it's quite a bit to read through, but please read through it. My partner is the one who's sort of taking on this project for our firm, but we're trying to put all these things into place as well. In terms of employees, have any of you had any employees who have refused to return or do not want to return?
Hi, this is Zenobia. So I have two questions. The first question was the language that you were talking about that's listed on the governor's website, and the postage and stuff that you have to have, or the posters you need to have posted. Is that generic? Is it generic information that potentially could be created by the chamber and then sent out to all of our members? Or does it need to be created specifically for that particular business?
So the way I've read it is that it needs to be specific to the business. Now, there are some things that, of course, could be generic, but a lot of it would be, in terms of the social distancing and things like that, or how you're, the protective gear and all of that, it's going to probably be very specific to how your office space is laid out. Are you even able to keep a certain distance? So there hasn't been much that I've seen, and I imagine maybe this information will be provided by one of the state agencies that will maybe provide some general information. But because I would have to say I don't feel qualified to come up with a plan and policy that includes COVID exposure control, mitigation, or recovery plan. I'm not a medical professional, right? So I think there's some of that you can do, certainly with regard to how your office is laid out. Some of it I would say can be generic, but I think a lot of it is going to be very business specific.
Okay, thank you. And then the second thing, your question about employees not returning to work. I get calls, and we've been getting a few calls at the chamber about what happens when someone denies coming back to work. So we had a few restaurants that, thank goodness, because of the different promotions going on and drive-through, they have increased in their business. So sooner than later, so they're able to call people back to work. And when they make the phone calls, there's a variety of reasons. The top reasons being, number one, I don't have childcare because my child isn't in school, and so I can't return to work. The second one is I'm making more on unemployment than I am at the office, and so I would like to kind of continue my unemployment until that runs out. And then the third is I don't feel safe working in that environment. So, in the restaurant industry or in a small office. Those are the top three issues that our members are facing right now.
Okay. So I'll speak to some of it. And what I will say, so about the employees that are, let's start with the employees that are refusing to come to work because they're making more on unemployment. If you as an employer have put in the safety measures that are required of you, and you have a job for that person, and that job is, you haven't significantly changed the job, so you haven't either moved the job location or you haven't significantly cut their pay. If things are the same with their job, you as an employer have put safety precautions in place. That employee cannot refuse to come back to work because they're getting more in unemployment. If they do that, then they actually can lose their unemployment benefits. And so if the offer to return to suitable work is there and an employee refuses solely based on because they're making more money in unemployment, then it's not a good cause. It's not a protected reason. And so they are not able to do that. And usually what happens is when an employee files a new unemployment benefit claim, the employer is usually notified. And so the employer then is able to dispute the employee's claim that, they didn't have a job to go back to. And an employer can actually be proactive, and in those cases can call the Employment Security Department, the ESD of Washington, and let them know, you can let them know, hey, I've offered them, they have the opportunity to return to work, but they've refused. So that's one thing that they can't do. So as long as you've done your part as an employer, you haven't really changed their job, and they have an offer to return, they can't refuse based solely on money. Now, there are some good causes that can, where an employee may refuse to return to work and they can continue to collect unemployment. So some of those, and this is one where it goes into sort of a fact finding where you have to assess each individual employee's claims. And it can be a lot. It can be a lot for an employer. And so this is where you would need to contact, your attorneys or a really good employment attorney, because you've got not only local state regulations, you've got federal regulations, you've got, OSHA, and you've got, do you have to provide any accommodations based on disabilities and things like that. So some of the good causes under the new, it's the CARES Act, and then there's another act that I can't recall the name of it, but the Pandemic Unemployment Assistance. So there's a couple, actually that's under the CARES Act. So some of the good reasons could be that if that employee is sick with COVID, or they're taking care of a household member who's sick with COVID. If the employee is forced to stay at home because they have to take care, they have daycare issues, and their kids' school is closed, then they also could have good cause. So it really is sort of a fact-dependent, kind of issue. You're gonna have to talk to the employee. You're gonna have to figure it out. There's also several different laws that may apply. It might not just be one. There's lots of different things in place to protect employees. So you're kind of gonna have to do a fact finding at that point. And I think someone's unmuted. I can hear. Okay. Are there any more questions? All right, great. Okay, so some of the good resources, I'll just say, the Employment Security Department does have a really great Q&A. It has, FAQs for employers and employees. So that's a really great place to go and look. I mean, I know that department has been swamped, but they've been trying to keep up, because it's not surprising. They've been getting a lot of questions from employers saying, I have employees that are refusing to come back because they're getting this extra $600 a week, which I think is only in place until July 29th. So that's a good resource and a good place to look and start. Okay, so I know some of you had mentioned, or at least one person for sure, that they use independent contractors. And so one of the issues is that we found with small businesses, there's definitely lots of benefits to independent contractors. Small business owners like to use them, but there is a very thin line between what constitutes independent contractor and an employee. And so a lot of the issues we've seen have been where businesses are getting audited, or they're getting fined, or there's issues that, there's problems where an employee might or a worker might go and say, hey, they have me as an independent contractor, but really I'm an employee. And so, I have the definition of what's an independent contractor, right? It's somebody who is, you are usually hiring someone for a specific task or several types of tasks. But it's different from an employee, because an employee is there on an ongoing basis. They're being paid for their time versus maybe being paid for the specific task. And the best way to kind of determine whether is your independent contractor a true independent contractor, or are they an employee, is this notion of control. Is how much control are you exercising over this individual? Are you controlling, are you telling them that they have to come to work every day at your office from Monday through Friday? Or that, even if they're working somewhere else, you're telling them, well, these are the specific hours they have to work. Or are you just generally saying, hey, I need about 20 hours, you do it whenever you can or whenever you want? Are you telling them, for example, if you need somebody to do a piece of graphic design for you, are you telling them how to do it, what software to use, what exactly you want? Or is it just you're saying, hey, this is kind of what I'm looking for, you do it however you're going to perform the task, versus you telling them exactly how it's done? So this notion of controlling their behavior, controlling, kind of like the instructions, the relationship, all of that is really going to determine it. And there's several different tests that courts use. The state has its own test, there's federal tests, but that's just the one big pitfall that we've had is, I know small businesses who love to use independent contractors because they don't have the tax obligations. You're not required to pay, overtime, minimum wage. There's no benefits, anything like that. There's no workers' comp, but it's really an employee. So a lot of times if you have somebody who is an admin, a secretary or something of that sort, they're most likely going to fall under the employee category and not really be an independent contractor. So that's something, while we're on this topic of employees, that's something to really look out for. Okay, what time is it? It's 4:43. Okay, so we're kind of in our final topic of succession planning. So how many people have thought about succession planning in their business, or actually have a succession plan in place? Does anybody want to share?
This is Zenobia. I don't have a succession plan at the chamber. We just have a strategic plan that I would hope would act as a succession plan, which is probably not the best answer. But that's what we have. And there's something in the chat.
Yep, and I see from Sarah that you're working on yours. Great. It's your father's. That's so, Sarah, that's wonderful that you're working on it now, you know, while he's still here and he's planning on retiring. So what is a succession plan, right? Basically, it's your exit strategy. It's your exit plan for a business owner who, when they are ready to be done with their business and go on and retire, or maybe they just want to do something different in life, or if something unexpected happens, like death or disability. You know, unfortunately, those things are unexpected. They happen all the time. And if you don't have something in place, this business that you as a business owner have worked so hard for, oftentimes can just be shut down or run into the ground. So if you don't have a plan in place, you risk losing your business, and your family risks losing what you've worked so hard for, you know, for probably their benefit as well. So this is something that there was a Wilmington Trust study done saying in 2017 that about 60% of small business owners did not have a succession plan in place. And this is something that really, it's kind of, you want to think about it at the beginning before the end even is near, or before the end comes. It's something that it's hard on day one, of course, of your business. You're excited about the new business. Who wants to think about what happens if you're no longer in the business or the business ends? But what happens is we're all busy entrepreneurs. We're all busy running our day to day. And this gets completely pushed out to the back burner. And so a lot of times something unexpected will happen and somebody won't have things in place. And it makes it very difficult, not only for their employees who may love the business, but also for their family members. So these are a few things that you should be thinking about when you're thinking about, what does my succession plan include? What should it have in there? So it should address, of course, your ownership. It should address your operations, right? How you conduct your business, your processes, your systems. It should include the tax implications, because you know, depending on how much your business is worth, Washington has estate tax. So this is where you're gonna work with your CPA, you're gonna work with your estate planning attorney to come up with, are there ways for me to avoid that? And, you know, are there trusts? What are the things that I can do to avoid paying out all this money in tax? And then that aligns with your estate plan, of course, because it's not just your business, but it could be your other assets as well that puts you over that estate tax threshold, which in Washington individually, it's right around 2.2 million. And as a community property for a married couple, it's 4.4 million. So if you think that cumulatively with your house, your retirement, your insurance, and your business, you're going to be over that amount, you're going to have to do some tax planning. You're going to want to think about who's going to own the business next. You know, how are they going to manage it? Do they know how to manage it? If it's going to be something that's going to be passed down to a family member, there's multiple family members or there's multiple business partners. How are you going to avoid deadlock in the future? Is one party going to have, you know, more shares or more ownership percentage? You're also going to want to figure out, just, are you going to want to sell your business? You know, maybe there's nobody that wants to take it over. And if you're going to sell that, you want to make sure you have proper things in place. So if you're a sole owner of a business, and I'll say this applies not only to sole owners, this also applies to partnerships or multiple owners. One of the things that's important to do is have a disaster file or a binder. Or, you know, most things are electronic now. So of course you can have it somewhere, you know, in your cloud, Google Drive, whatever, Dropbox, whatever it is you guys use, just make sure that somebody knows where to access it. And that document should have It should have your financial, that folder, I should say, should have your financial records, general accounts and passwords. It should have contact information for your attorney, your CPA, your insurance broker. Maybe you have a business broker. Maybe you have somebody that's going to sell your business, your banker. It should include any manuals or processes or systems all in one place, because what you want to do is you want to make it easy for that person, that next person, to kind of take over. And so that's mostly going to come into play if something completely unexpected happens. If right now you have the opportunity where you know you're going to want to retire soon, or you're going to want to have a change in ownership, you can start now. You can identify, a successor in interest. You can, of course, talk to the successor so that they know what's happening and that they want to accept this position. If you've got a family member, so if your business is staying in your family and you already have someone in your family who's going to take over, or maybe you have an employee, a very loyal employee who's been with you for a very long time, you can write up the documents now for their, an option to purchase before you pass away or before you become incompetent or something may happen. So you have an opportunity to put these things into place now. The other option is you can start selling. You don't have to sell your entire business. You can start slowly selling your shares. Let's say you want to retire in 5 to 10 years. So you can slowly do that. And over time, then completely, you'll have time to train and transition a new successor and a new person. So these are just some things to consider. These are definitely some things to consider. And it can be, a lot of times this is put on the back burner because you have plenty of other things going on in the day-to-day of your business that the last thing you want to think about is, well, who's going to manage and run this, or am I going to sell this, or, but it's extremely important. It's extremely important. And I would say, this applies both to sole owners and to partners, is when you have your personal estate planning documents, you want to make sure that your succession plan mirrors your wishes in those estate planning documents. And then some special considerations, I would say, for multiple owners. So usually, with an LLC, you should have a written operating agreement. And that written operating agreement, it can be called a partnership agreement, an operating agreement. It's generally an operating agreement, but some people refer to it as a partnership agreement. It should outline what, how, what, when, where, all the terms of if one partner wants to sell, or if one partner wants to retire, how is your business going to be valued? Is there a different valuation that you want to agree on every year? Or do you want to do, an appraisal, or you want to get a business broker? I mean, there's lots of options. It should outline the terms of your buyout. A lot of times you'll hear the term buy-sell agreement. Buyouts are funded by life insurance. So the partners of the business will have life insurance. And if something happens to one of them, their life insurance would be enough to, the life insurance would be enough to sort of buy out that partner's share. The other thing you could do is you could have a loan. Maybe say one partner passes and the other partner has a loan to that partner's family for 5 years, and they have to pay them over 5 years with certain terms, certain interest rates. So there's lots of different ways it can be done. It's just important that you start thinking about it. The one thing to be aware of for a multiple owner business is, let's say your business partner passes away. Well, you don't want to be forced into business with their spouse or somebody, one of their family members who's not interested. So this is why it's very important that you have the opportunity to buy out that share, that partner's share, or that if maybe one partner is no longer part of the business, you have an agreement that, okay, well, the business is going to be sold, and the proceeds, you get your percentage and the estate of your partner will get the other percentage. So these are things that you want to definitely keep in mind. The last thing I will say is that if you have a professional service business, for example, us as attorneys, if I pass away, my husband can't take over the business for me because my husband is not an attorney and you're required to be licensed. Same goes for hairdressers or, you know, things that require a license. So just because you have a business, you want to make sure that the person who you are having take over can actually legally operate that business. And similar to, you know, as a sole owner, even if you're a multiple owner, you want to make sure that your wishes are the same in your estate planning documents as your succession plan. And I think that is all I had planned for today. So I don't know if anybody has any questions. I'm so sorry that the first part of that was just so hard to hear. But I'm happy to send out this PowerPoint, and if anyone has any last minute questions, I'm happy to try to address it.
Okay. Well, no questions. Well, thank you so much, Cynthia, for that presentation. I mean, you know, we can't, technology is just not that reliable. Even our little chat this morning to get it working, you know, so we tried our best and that's all we can do.
I know, I was going to say, of course, everything was great during our test this morning. That was completely fine.
But I do appreciate your time, and I just wanted to let everyone know on the line that this has been recorded, and with her permission, I will be sharing this information out. And along with that will be the presentation. But I think more importantly is, you know, Cynthia is a chamber member, and so her information can be easily found on our chamber website if for some reason you can't look back on this, and maybe scheduling some time if you have more in-depth questions. I know that she has multiple people in the office that could potentially help with different parts of your business. And so feel free to reach out to her. And as it relates to COVID-19 and planning and signage, we at the chamber are really working to figure out, you know, what businesses are eligible and what phase and what will be required of those businesses. So just keep an eye out for that. And if you have any information you want to share to other members or to the chamber, we are definitely open. So I appreciate you, Cynthia, taking the time today, and thank you for everyone on the call.
Thank you all so much. I appreciate your time.
Okay. All right. Bye-bye.
Bye.